a majority of 2-1 decision of the Guyana Court of Appeal declared that more votes used in the Constitution means more valid votes. Now, on its face, nothing is wrong with such a declaration, because whenever the law uses the term votes, obviously the law means valid votes. Unfortunately, APNU+AFC have grabbed on to that and are now contending that the Chief Elections Officer must only count what the Chief Elections Officer determines to be valid votes. And we already have evidence before the Commission that the Chief Elections Officer, in an unlawful and fraudulent act, discounted and rendered invalid some 275,000 valid ballots as invalid cast at the last election in his observation report to the Commission. 275,000 votes constitute about 60% of the votes cast by the electors at the last elections. And that when you deduct that, and he deducted it from the PPP, leaving APNU with a 2/3 majority in the National Assembly. Now, as I said, APNU+AFC have held on to this Court of Appeal ruling and are now interpreting it to mean that Keith Lowenfield can arrogate unto himself the power to determine what is valid votes. And as I said, can make the deductions as aforesaid. Now, that's a dangerous risk to run, because although the Commission itself has determined that it is only valid votes that were counted at the recount exercise, and only valid votes tabulated on each SOR, and only valid votes tabulated and certified for each electoral district, which resulted in a total of only valid votes in the end in a report that Lowenfield submitted. But of course, you cannot trust the Chief Elections Officer. He can very well now alter that in his final report and, using the language of the Court of Appeal, obviously wrongly, deduct 275,000 votes and present a report to the Commission and argue that the Commission is bound to accept that report. So it's against that backdrop that we believe that, out of an abundance of caution, we will appeal this matter to the Caribbean Court of Appeal.